webinar for right now, because this is not going to be any regular webinar where we are going to teach you strictly law and how to legally protect. Just it's not going to be a plain session of that. So this is going to be a first of its kind webinar where we will now help creators and how they can monetize their creation and how to do effectively from the start till the end of the creation of a film. So I welcome you all to this webinar titled Legal Lifecycle of a Film, Conceptualization to Monetization. This is going to be a guide on how to safeguard your rights and exploit them. I am Shakti, legal executive at IP Client, and I will be acting as the moderator of this webinar. Before we begin our session, I would like to explain in detail what we do at IP Client and how we are of help to this creative community, and how we equip creators and our how we aid them in getting their rights as well as their IPs protected, monetized, and everything. So at IP Client, we deliver end-to-end legal and IP services for films as well as creators. From the development to exploitation, we secure, structure, and manage IP assets covering rights, clearances, contracts, complaints, and risk mitigation, ensuring creators and artists. We also protect, control, and fully leverage the value of their intellectual property, that is the creator's intellectual property, be it a script, be it a lyric, be it a music composition, or be it a story. We protect all IPs of all kinds related to the media and entertainment industry. So we also have a set of curated tools aiming to serve a large purpose, and which shall be of help to all the creators, producers, and filmmakers. We have started launching one by one, so stay tuned to ipclimb.com in order to gain further more exposure and more knowledge about what is coming right at you, which will be of huge help to all the users. Also be the communication details in the chat box in just some time. So that is about IP Client. And now jumping right into today's session. This session is articulated, designed to walk you through the entire life cycle of a film. So begin with the conceptual stage are born. Then we will discuss how creators can protect their intellectual property from the outset at the whole. And then from there, we will move into development and production, exploring key agreements, rights management, and risk mitigation strategies that every filmmaker and producer should be aware of. Like at this point of time, currently, right now, legal knowledge about filmmaking and protecting your IPs is not just recommended, or it's not just it's 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 not just not so mandatory right now. I think it is mandatory, since the amount of exploitation and misuse of all the tech is at a very rapid rate that all the filmmakers and creators need to be aware of. As we progress, we will also cover the legal aspects of distribution, licensing, and monetization of a film. This includes how to structure deals, safeguard your rights across platforms, and ensure that your work, your creative work, your creation which you've created, which you've generated, continues to generate value in a sustainable as well as legally secure manner, and that nobody misuses it or exploits it without your consent, or gains a monetary advantage over you. To guide us through these crucial topics, we are delighted to have IP Client. I once again welcome Ms. Anushree Rauta, Equity Partner, A&M Global, and Founder, IPR Law. So, Madam brings deep expertise in media and entertainment law and intellectual property law, which Madam is a total expert at. First thought of a webinar on this topic, going to talk about the IPs and media and entertainment law, nuances of media and entertainment law. We at IP Client, we found ma'am to be the right fit, and then we approached ma'am, to which ma'am graciously accepted. Thank you so much for accepting this invitation, ma'am. Madam will now be sharing practical insights, real world considerations, as well as things which are generally done in the industry, and how to legally stay right from it, stay away from it, and of money, profiting. Over to you, ma'am.
Thank you so much, Shakti, for the kind introduction. And hello, everyone. So glad to be here. I've been given to understand that most of you are from the creative industry, and I'll try to make this as simple and with as less legalese as possible. I'm sure everybody here is somewhere or the other, um, everybody loves films, right? But what really goes behind that, what really is involved from the conceptualization to monetization when we see it on screen. So the idea for today's discussion is to understand what really goes behind the scenes. So I'll just quickly run you all through some basic concepts before we dive deep into each stage. So when we talk about a film, and for the purposes of this discussion, I'll stick to a feature film, which we typically see in theaters, or we see it on different mediums like our TV sets at home, be it through satellite or be it on platforms like Netflix and Amazon, which are OTT platforms. Um, when we talk about any film, the first stage which really comes is the conceptualization, the development, right? From development to the next stage, which is the pre-production, then actually going into the shooting, then what happens after the shooting is completed, and till the exploitation of it, what all stages and what all legal agreements are covered under each stage. I'll be taking you all through that. As well as towards the end, we will talk a bit about some of the legal compliances which every creator, every production house should keep in mind while making any film, which is something which we called as standards and practices, in short, S&P. So we'll be briefly touching upon that as well. So I'll start with the discussion for today. So when we talk about a film, a film is a cinematograph film under the Copyright Act. Now there are different elements to any film. We have a script, we have screenplay, we have dialogues, we have music. All of these are embedded, and then a film is made. But each of these constituents, which we say, right, each of them are a part of the overall puzzle. They all have separate rights as well. So when we talk about, say, a screenplay or a script, it has literary works as well as dramatic works, which are again protected under the Copyright Act. When we talk about music, which we, in simple terms, any songs which are put, that is a sound recording. Now, in that also we have lyrics and we have musical composition, right? So lyrics again is something which forms part of the literary works. Your composition forms part of the musical works. Each of these are separately protected under the Copyright Act. So depending upon different creators, right? So a writer would be an author of a literary work. A photographer would be photographs again form part of artistic work. So a photographer would be an author of an artistic work. Likewise, we have music composers, right? You have like Mr. A.R. Rahman. He is an author of a musical work. So there are six set of such works which are identified under the Copyright Act, and authors of these different kind of works have different protection under the Copyright Act. Now, when we say what is a copyright, right? Now, this is of course identified under our Copyright Act, and there are different kind of rights which one gets in terms of the works which they own, which includes everything from your reproduction of the work, the right to actually make the work, to communicate it to the public, to exploit it in different forms, to adapt it into something else, to issue copies of it. All of this is governed under the rights which the Copyright Act really gives to the various creators and the owners of the copyright. So to understand this better in terms of how this really flows, right? Because we all know that there are agreements which one has to sign with respect to the ownership, or when the work is created. Um, there are, of course, at different stages, different elements come. But since we are talking about the conceptualization to monetization, some concepts which you all should know and which we'll be using through our discussion are assignment and licensing. You all would have heard about these two terms very frequently, and sometimes people don't understand the difference. So just very simply, assignment means transfer of ownership, in a license, there is no ownership which is transferred. I'm just giving a limited permission to the respective licensee to use the work for certain purposes. So just reiterating, assignment is transfer of ownership. Licensing, there's no ownership transferred. Uh, in both, it can be given for a limited term. It can be given for a specific term, territory. But yes, it should be in writing, and these things should be identified. If say you do not identify the term in your assignment, then it automatically becomes 5 years. And if you do not mention the territory, it automatically becomes India. So it's important that certain clauses are always mentioned in these assignment and licensing contracts so that there is no ambiguity. Again, just a couple of requirements for a valid assignment license. It should be in writing. That is a requirement under the Copyright Act. It should clearly mention what rights are being assigned or licensed, the duration, the territory, the consideration, because without consideration, it would be deemed to be void. Um, uh, there is a provision under the Copyright Act which says that if you do not utilize the works which have been assigned within 1 year, then those rights lapse and they go back to the assigner. So that's why we always, if we are for the assignee, then we always have certain waivers which we mentioned that, Section 19(4) of the Copyright Act is waived. These things become important from a monetization perspective because without them, rights can go back to the assigner. So it's important to have all of these specified. Now coming to the commencement of the film. Now before even the development starts, right? Now say if I'm a producer and I want to make a film, uh, I will first want to identify whether I want to do it alone or do I want to collaborate with someone. Am I being commissioned by a platform to do it or by a studio to do it? Or am I an independent producer who wants to produce it on my own and just probably secure my financing through some private financer? So when a producer tries to take that decision, that kind of forms the framework of how the rights proceed. So say for instance, I'll take a recent example of say Dhurandhar, right? One of the recent films which released. You all would have seen that there was a production house involved and then there was a studio like Geo involved. Um, Possibly in these kind of arrangements, it could be like a co-production where two producers, like one studio and one producer, are coming together. One is deciding to put in money, another is just doing the entire production activity, and the nature of their relationship kind of governs how the rest of the agreements in the film flows. So when one does these kind of co-production agreements, typically say the production house which is involved, they will do all the further development, pre-production, production activities, and the say the other studio which is involved, which is putting in the money, could typically control all exploitation related rights. Likewise, say if it is a commissioned project where, say, a platform like a Netflix or an Amazon is commissioning a production house to develop and produce the film. In those kind of scenarios, the particular studio or the platform will be the complete IP owner and will be engaging on a commissioning basis, or we also use the term work for hire. They'll be engaging the production house to develop it completely, and then they will release it on their own, on their platform, or possibly sell it to somebody else. Um, if I'm a producer and I want to do it entirely on my own, but I need the finances, I may not have enough money to completely fund the entire project. I may just do a simple financing deal with, say, a private financer, take the money, find a way to, refund that money before the film releases, or maybe give it from the profits of the film and release it on my own. So, depending upon what the structure is, the further agreements flow. Um, there is also an aspect of whether my film is an original film or is it an adaptation of another project. Because before even we start the development stage, right, it's important to identify. um, for instance, we all have seen so many remakes. We have Hindi films which are remakes of certain South films, and vice versa. Sometimes there are remakes of international films. So if a producer decides that they want to make a remake, you first need to have your remake rights in place. For that, we typically do a remake rights agreement where the producer who's acquiring the remake rights takes all those necessary permissions and bases the rights which are acquired, the further contracts flow with respect to how the film is made. Likewise, it could be a book to screen adaptation where certain book rights are required to be procured. So either the author or the publisher, whoever has the rights, depending upon their contractual arrangement, the rights are required to be procured from them. So in these cases, we enter into what is called as a book rights adaptation agreement, where the necessary rights are taken from the respective right holders or the owners of those books to adapt it into a screenplay for a film to be exploited. And each of those, of course, have their own nuances in terms of the rights which are commercially negotiated. It could be possible that, for instance, in a remake, the remake right, the person who's giving me the remake rights may put certain conditions that you can make it in only one language and not in other languages. Or basically have certain other restrictions with respect to how they want the remake to be made, certain creative controls, so on and so forth. Then we also have real life event adaptations. In certain cases, you may have seen that there it could be, say, historic event. It could be something which is based on a particular personality, like a biopic, or it could be which is based on some case which had happened. Depending upon what those real life scenarios are. For instance, if it is based on a particular individual, if it's a biopic, then and if the individual is alive, then necessary personality rights, the biopic right agreement, that needs to be done with that individual. If the person is not alive, then of course there is an entire jurisprudence which goes into whether rights are required to be taken or not. And likewise, if we are basing it on, say, we see so many films which are made on certain wars, on certain historic events. Um, a lot of these are in public domain and people are free to make it. But yes, wherever you're showing any personal life of an individual, certain rights are required to be taken, and one needs to work within the framework of law to ensure that there's no nothing derogatory, there is no defamation, there is nothing which has been shown inaccurately, which is not as per the public records. All of those things need to be taken care of, and necessary agreements are to be taken wherever you're, from the personalities or whoever is being depicted. So moving on to our first stage, which is the development stage of a film. Now, when we say development, it is really where you start your conceptualization, where your the idea to the detailed expression is really, the idea is translated into the expression. So there are different kind of agreements which one has to enter during the development stage. One would be your core development agreement, depending upon whether if there is a studio which is entering into a development agreement with the production house, or a producer who's producing the film on its own is engaging certain writers to write the script, the basic stories. So that would entail your script writer agreement, the screenplay writer agreement. If certain rights are to be taken just to see whether the film is to be made on a particular book or any of those, there could be an option agreement which could be done. Now, an option agreement is something where parties are just testing whether they want to really take the assignment subsequently or not. Because once, for instance, say if I want to make a remake of a certain film, but I'm not sure if that will really work out. And I don't want to pay the entire remake right fee to the person from whom I'm procuring the rights. I'll do something which is called as an option agreement, where I will develop my script. I will see if it is really working out. I may go and reach out to certain director or say an actor to see if they are interested. And if it works out, then I convert the option agreement into a proper assignment agreement, where I actually go on and take rights. So all of this is decided during what we call as a development stage. Once the producer is sure that they want to proceed with the agreement, we call that as green lighting. So once the project is greenlit, then it goes on to the next stage, which typically is the pre-production stage. Now, Pre-production, as the word itself, as the term itself explains, right? It is what happens prior to the actual shooting of the film, which, before the actual shooting starts. So in the development stage, we talked about the writers being engaged, the script being developed. Now, once the script is developed, a director will possibly be identified, because without a director, you really cannot do anything with respect to the film, right? You need a director first who can come and direct the film, and basis that the actors are then involved. So once a director is identified, then there are narrations which happen with possible actors. Say if a particular actor likes, is onboarded, then all of these agreements are signed with respect to locking them. So all of this happens during the pre-production stage, where your director agreement, your lead artist agreements, all your so-called above the line agreements with respect to the head of departments, your cinematographer, your the cast and crew, which is typically engaged for the film. All of that is identified, and those agreements happen during the pre-production stage, where the entire preparation is done. The recce is done by the producers, that where do they want to shoot it. All of those arrangements are done. And after all of this is put together, where the entire cast and crew is identified, locked, their payment terms are decided, the budgets are decided, the shooting locations are decided, then comes the stage which we called as the production stage, where the actual shooting happens. Um, Now, obviously, when you're going to shoot in a certain location, there are certain permissions which are required for each of those locations, right? One cannot just simply go and shoot anywhere where they want. So, in those scenarios, you have, or say if you're shooting in a studio, um, there are certain agreements which need to take place with the studios, with the particular location. There are certain permissions which are required for each location. There are certain police permissions required. Say if you are engaging, there are certain child artists, for instance, in any project, then certain district magistrate permissions are required. Um, so this is something which typically the line producer, which is involved for that location, will take care of it and will do all the liaising with the different departments, the different people for whom the permissions are required. And all of this is done during the production stage, and where the actual shooting happens. So we started with development, we went on to pre-production, and then of course the main shooting, which happens, is what we call as the production stage. Um, there are typically production schedules which a producer determines. Sometimes the entire production may happen in one go. Sometimes it happens in different schedules, where it may happen in, certain durations. It may not happen back to back, or it may happen in different locations if it's not happening in one specific territory, right? There are sometimes overseas shooting. It happens in different locations, even if it is in India. So each of those has different compliances required depending upon where the film is being shot. Once all of this is done and the film is shot, uh, we come into the next stage, which is the post-production stage. Post-production, now, as the name suggests, it is the stage where actually the entire editing, dubbing, putting everything together and ensuring that the film really comes into play in terms of how it's shaping up. That responsibility, all of that happens during the post-production stage. And there are various agreements which are also executed during this, be it with respect to the laboratory which is involved in terms of now, of course, things are like, with digitization, there are earlier there used to be like the proper reels which used to be kept, the physical reel used to be kept in the particular laboratory. But now, of course, it is all digitized and kept on hard drives. Um, there are visual effects, VFX agreements which are done with the VFX studios. The dubbing happens during the post-production stage, where all the voiceover artists are required to come and dub, and all of that is synced together to form the film. So anything to do with respect to making the scratch version, then making the first cut, getting everything properly into place with respect to the film, that happens during the post-production agreement, during the post-production stage. Now, once the film is made, right? Once the entire film is made, um, what really happens after that? So we, of course, when we talk about marketing, which is very important for seeing that your film is actually monetized properly and it reaches its audience. There are various agreements which happen even for the marketing stage. Um, you may have seen that in certain films there are certain brands which are showcased. There are certain products which you may find which are there placed inside the film. uh, it's not allowed to just randomly have those brands there without permissions. So sometimes brands come and they tie up with the producers, where there are certain agreements which we call as in-film placement or the brand integration agreements, where those specific brands, of course, they have certain commercial arrangements with the producers, and basis whatever commercial arrangements they have, their brands are showcased in the film. This is also part of the marketing strategy. There are a lot of promotional tie-ups, a lot of endorsements, guest appearances. For instance, you see the cast and crew appear in certain shows. They go and do on-ground events. They appear in certain television shows or in reality shows. So all of this happens during the marketing stage of the film. And of course, there are different agreements for each of them, which govern with respect to your publicity, the public relations. All of this forms a part of the marketing stage where the producer invests that money to ensure that the marketing of the film is properly done. And then, of course, the most important part where we reach the monetization once the film is made. How do you really make the money? Now you've made the film, but how do you really see that the revenues are coming from it? Now, this is done when we talk about the feature film. There are essentially four main ways of monetizing it. The first one, and first I'll tell you all about the four phases and then go on to the details of that. The first one being the theatrical distribution, which happens when you see the film in the cinema theaters. Second is your OTT, your digital exploitation, which is through the OTT platforms. Third is your satellite exploitation, which happens on with respect to what you see on your satellite television channels. And fourth is music, which you all would be hearing the music not just as a part of the film, but on YouTube, on Spotify. And those rights, of course, are taken by the music labels. Right? So these are the four main avenues. And in addition to these four, of course, there are some ancillary avenues as well. For instance, in flight, when you go on certain airlines and you get to watch the film on the screens in the airline, or similar to that, there are other surface transports like railways, like ships. Those are ancillary. They do not form the major part of the revenue, as we say. That is why we term that as ancillary. So when we talk about theatrical distribution, um, see, different films have different scales, right? Now, some films may be like really big budget films with those superstars in it. Some may be slightly medium budget ones, some may be slightly smaller ones. Uh, Depending upon what the film is, different kind of deals are done between what we call as distributors. So a producer who has the rights, a producer or a studio, whoever has the exploitation rights of the film, will do a theatrical distribution deal with a distributor. Now, to give you an example of distributors, we have, for instance, for Bollywood films, there is an entity called as Pen India Limited. There is A Films. They basically take the theatrical distribution rights, and they have a certain deal with the producer, and they in turn have back-to-back deals with the exhibitors. Exhibitors would entail all your cinema chains like PVR, Inox, so on and so forth. All the theatrical, the multiplexes, the single screen theaters, all of those form a part of the exhibitor chain. So when a producer does a deal with a theatrical distributor, um, now with the current market, minimum guarantee deals are slightly rare, but For the purpose of this discussion, I'll bring that across as well. So minimum guarantee is a deal where the distributor is sure that the film is going to do really well and decides to pay the producer an X amount, which is a guaranteed amount that regardless of how the film does, the distributor is giving the producer an X amount, and whatever comes over and above that will be shared in a particular ratio as per their commercial understanding. That is what we call as a minimum guarantee deal. What is now very prominent is something which we call as a refundable advance, where the distributor gives, say, an X amount to the producer, says that this amount you can keep, but say if the movie does not do a certain number, and if I'm unable to recover this entire amount which I've given you, then you will have to refund the shortfall to me. So it is that way is a low risk for the distributor because even if the movie doesn't do well, they will recover that amount back from the producer. That is what we called as refundable advance because any shortfall is required to be refunded. Then if the distributor is not sure about the film, or say if they do not want to take a risk for whatever reason, because these days theatrical exploitation, there is a little uncertainty in terms of how the film may perform. In those kind of scenarios, they do something which is called as a commission based agreement, which is very simple. I'll distribute the film for you, I will take an X percentage of commission for that, and you keep everything else. They'll tell that to the producer, which is a low risk for the distributor. So when, of course, wherever there is a profit sharing, where the distributor keeps a certain profit, they will first, of course, recover whatever amounts they have incurred towards any publicity, any P&A expenses, which we call print and advertising, VFX cost, anything on those lines. And after that is recouped, they will share it between with the producer basis whatever the commercial understanding is. So these are typically the kind of theatrical distribution agreements which take place. Coming on to the next one, which is your satellite or what we call as linear rights. Uh, Now we have various satellite channels like Z, Sony, Star, Sun TV. All of these are satellite channels. Now, when a satellite broadcaster enters into an agreement with a producer, uh, there are two things which the producer really has to take care of. That if the OTT partner is a different partner, it is not a part of the same network, obviously. You have to ensure that there's no overlapping of rights. So in these kind of deals, they are, of course, for a specific term, for a specific territory. Now, if it is a broadcaster which has a network throughout the world, or where they have a distribution network throughout the world, they will typically take the rights for the entire world. These rights are called as linear rights. Linear meaning where the viewer does not have control in terms of controlling while viewing the particular film on their television program. So where there is control by the viewer, it is called non-linear. Where there is no control, it is linear. This is an important distinction, which a lot of times people get confused in terms of what are linear rights. So it's very simple. Where the viewer does not have control, it is linear. Where the viewer has control, it is on demand, or what we typically cover under our digital rights. So there are different kind of linear rights which these kind of agreements cover. I'll not go into like in-depth detail about it, but some of these rights are there on the screen. Satellite broadcasting, which is your basic, what you see in terms of the satellite channels. Terrestrial television is, to give a simple example, Doordarshan, right? Where you would remember that back in the day, those antennas used to be there. That is how these terminologies have come into place. Cable television again is what flows through the cable television network. IPTV is Internet Protocol Television Network, which is again routed through the satellite broadcasters. And then there are different subsets which we call as hits, direct to home, the way Tata Sky is there. And flowing from that, you also have your simulcast these days, because a lot of these satellite channels also have their simulcast, in the sense you're live streaming of the same channel on their own OTT platform. So these rights typically get covered under the satellite right deals. Like I mentioned, of course, there are payment terms involved. Here also, typically, of course, there is a fixed fee which is given by the satellite broadcasters. And sometimes now, with changing market, different type of terms come into existence. So, for instance, if there are something called as theatrical kickers. So, if a film has done exceptionally well, then while negotiating the agreement in advance, the producer may say that, okay, if my film does a certain number, then you will give me an additional amount. Or say if the TRP of the film is really, if it goes beyond a certain number, then certain incentives should be given for that. So these are the different kind of commercial understandings under the satellite right deal. Uh, Now, when we talk about digital or the OTT exploitation, which is all your Netflix, Amazon, Z5, AHA, all of these platforms, right? This is something which we also call as on-demand rights. Now, on-demand is what, right? They have different kind of on-demands. So, say for instance, a Netflix is a subscription video on-demand platform, which means where the subscriber really gives a subscription fee for being able to view it. A YouTube would be it also has a premium version which would be subscription, but it also has a free version which is only through ads, which is called as advertising video on demand. There are certain platforms which would be a hybrid of both subscription as well as advertisements, like JioStar, and so on and so forth. So, these are the different kind of on-demand platforms. They, of course, whenever a producer enters into any deal with these OTT platforms, and this forms like after theatrical, this forms one of the biggest revenue earners for any producer. Um, there are different commercials which are negotiated with each of them. So, of course, there is a certain term, territory, what kind of rights which are being licensed. Um, all of those need to be covered and captured adequately. Uh, there is something called as holdback. Now, you would notice that once the film is released theatrically, it does not automatically come on the very next day on your OTT platform, right? Now, why does that happen? Obviously, any producer, or for that matter, any exhibitor would want to have a certain window in which they can monetize and exploit their film and make some revenues out of it. Because if it comes on your TV screens the very next day, then nobody will go to the theaters. So obviously there are some industry understandings. This is not statutorily governed, but there are understanding between different associations of exhibitors and producers that there will be a certain holdback window. Okay, when we say holdback, it means you have to actually hold back the film from coming onto that platform for a certain duration. So, for instance, for Hindi films, it is 56 days from the theatrical release. So, you will not see any Hindi film coming on your Netflix, which is theatrically released 56 days before it comes on your OTT platform. Likewise, for certain other territories, it could be slightly lower. For instance, for Telugu films, it's 28 days, or sometimes, depending upon what the arrangement is, it could be slightly different. So, this is what is called as holdback on exploitation, which, as a producer, when they do the deal with these OTT platforms, they ensure that that holdback period is mentioned so that the OTT platform does not showcase the film before that stipulated time. Because if they do, then it becomes a breach of the theatrical agreement. So it's important to ensure that those holdbacks are adequately mentioned. Of course, when an OTT platform takes the film, and this I'm talking about, say, a new film, not talking about old films which have already been exploited for several years. Now, when a new film deal is being done, uh, a platform which is putting in a good amount of money will obviously not want it to come on a competing platform, right? So that is what they call as exclusivity, where they lay down that this will be exclusively available during the license period, for only on their platform, and certain terms and conditions and those restrictions are placed. Again, in terms of how the payment structure works for all these OTT deals, there is obviously a fixed amount which is there. in certain kind of deals, which is not very common, but there could also be a revenue sharing understanding if there is no fixed amount which is being given. Say if it is an advertising award platform, as we call, where they are not putting it on subscription, but they're putting it only from advertisement revenues. There could be a revenue sharing arrangement. So depending upon the kind of platform, those commercials are obviously determined. And each agreement, be it satellite, be it OTT, each party would want to have certain safeguards. Tomorrow, say any dispute happens, any claims come. These are governed by certain legal clauses. Uh, wh- you may have heard the term representation, warranties, indemnity, right? What typically these clauses entail are, for instance, from a platform's perspective, they would want to ensure that the film is original. There are no IP claims which come on it. It is in accordance with applicable laws. It is not, for instance, it is not hurting religious sentiments. There are no cases which suddenly happen because it is being streamed on their platform. So they take certain representations as statement of facts and truth from the producer to ensure that they have the rights which they are giving. It is encumbrance free. There will not be any claims, and of course, should there be any claims, then they would want protection from such claims, which is what is covered under indemnity. Basically, where the producer is promising that, okay, if I am in breach of the representations which I've given you, then I'm protecting you by way of indemnity. So these clauses are obviously covered in each of these exploitation agreements. We also have and a new right which is now emerging, and for which there has been a lot of discussion of late, in terms of that there should be some regulation on it. It's called as fast TV rights. Fast TV is basically linear but on internet. So you are watching something without being able to control it. That is why linear, and but it is on internet, so it's live TV streaming basically on internet. So it's now there are some platforms which have come solely for these fast TV rights. I mentioned earlier about some ancillary exploitation rights. So these include your dubbing, subtitling, in-flight entertainment, surface transport, home video. Earlier we used to have DVD, CDs. Now, of course, it's not really, it's almost become redundant, but those were also avenues for monetization. Merchandising, you would have seen, there are certain um, what do you say, merchandises like t-shirts, mugs, all of those, for which may have certain characters. All of those form under merchandising. And syndication, of course, is further sub-licensing. In addition to that, of course, like I mentioned, there is also, music of the film. Now, music is a different ballgame altogether, because there typically, traditionally music labels who are involved would want to take the entire music in perpetuity, and would want to they typically give up a fixed fee. Sometimes there is also revenue sharing, and all the rights in terms of the music of the film are taken by those music labels. Those music labels in turn further distribute the music to different platforms, be it on YouTube, be it on Spotify, be it with respect to public performance when it happens, which you hear on with respect to your hotel chains, or where it is being played in a pub. All of those monetization avenues are controlled by the music labels, and that is, of course, a different stream of exploitation altogether. Um, so these are the main avenues in terms of monetization of film. Uh, Having concluded in terms of what our monetization, I'll come to the last leg of what we talked about, which is standards and practices, which are very essential for every creator, every producer, to ensure that their film is in compliance with applicable laws. And this is where the role of lawyers also become very important to guide their respective creator clients to educate them on the requirements. So there are different legislations, different laws in India which are required to be adhered to. Um, in terms of when we talk about media entertainment, we have Cinematograph Act, which covers public exhibition of film in theaters. So you all would obviously be you all would have heard about CBFC, right? Central Board of Film Certification. No film can be exhibited in a cinema house without there being a CBFC certificate. And one gets the CBFC certificate only if your film is in compliance with applicable laws. Likewise, for television, we have Cable Television Network Act and the rules thereunder. For digital, we have Information Technology Act and the IT rules thereunder. So each mode of exploitation has certain acts which govern them. And of course, in addition to that, there are general compliances which are standard regardless of which mode or medium it is. For instance, you all would have seen the tobacco and health warnings which are there, right? So whenever there's a smoking scene, those statutory mandates are there with respect to showing that smoking kills or smoking is injurious to health. Likewise, when there are animals which are being shown in the film, you need to procure certain permissions from Animal Welfare Board of India. When there are any minors which are being shown in the film, you need to ensure that you are compliant with the NCPCR guidelines. NCPCR is basically your National Child Rights Protection, the commission for that. And there are certain guidelines which have been laid down by the NCPCR for audiovisual content. So those need to be strictly complied with. Certain permissions need to be taken. In addition to that, there are various statutes across. For instance, you cannot show the Indian flag in a derogatory manner. You have to ensure that it is shown in a proper manner. If you do not do that, you can invite claims. You need to show your police and armed forces, the uniforms, all of that in a proper manner. We see so many cases which happen when these things are not taken care of, and all of this is a part of what we call an SNP. So to ensure that your film is in accordance with applicable laws, with respect to even say religious sentiments, or whenever you're showing anything to do with anything which is religious in nature, it needs to be ensured that it is being done, in a manner which does not hurt the religious sentiments of any particular group. Um, Likewise, the language which is being used. So all of that for different mediums, there are different requirements. What may necessarily be for television may not be true for OTT. Television, of course, it's being broadcast, so it's there are more stricter laws for that compared to OTT, where it's been relaxed to a certain extent because it is self-regulated. Another important aspect which we look into from an SNP perspective is showcasing of third-party brands, third-party intellectual property. Um, you cannot just randomly use somebody else's music and put it in your film. If you do that, then you will get a claim. And we see so many such claims happening, right? So these things also need to be ensured in an SNP, where you have to, if you're using any music, then you have to procure proper licenses for that. Otherwise, you have to develop your own music. You have to ensure that there are no identifiable details of any person which are showed in a film. For instance, sometimes we see that somebody's phone number is being used, and that person is then being harassed. Like there have been very amusing cases, or say somebody's actual Aadhaar card is shown in the film. So those are personally sensitive information. One has to fictionalize and show all of these things. All of this becomes very important from a SNP perspective. Um, Having covered all of this, so we started from, when we talk about the life cycle of a film, like we see it is not that the film just comes on its own. There are different stages, right from your developing of the concept to your pre-production to production, to post-production and to actual exploitation which happens, and the various laws which are there around each of these governing what content can actually be shown. So it's while these multiple stages are there, each of them require different compliances, different type of agreements to be entered, and effective legal planning across each stage. It ensures smooth exploitation across platforms and also helpful for the monetization of the film. So yeah, I'll conclude with this, and we can open the forum for any questions which anyone may have.
Sure, ma'am. Thank you so much, ma'am. Participants, you can shoot your questions, or if you are not comfortable in turning your mic on, you can put it in the chat box and I'll convey it to ma'am. I think your session was so clear that nobody has any doubts.
I'm glad to know that. I can see from Anmol there's one question on film adaptation agreement. Anmol, do you have any specific question on that, or is it clear? Happy to answer any questions which you may have on adaptation. Okay, he's saying it is clear. There's a question from Shibika. What are the platforms that provide jobs related to this? Okay. See, I mean, when we talk about films, of course, you know, there are no specific platforms, but every production house, every studio, they have different, for instance, for actors, there are casting directors, right? Now, casting directors are the ones who actually identify the talent and do the screen tests. When it comes to writers, again, it's the producer's call in that sense. So these are all independently driven by the respective production houses. There's a question from Nishika. In case there are remixes of songs being used in a film, are there any separate rights required first from the original and then to be used in the film? Recently, there was the case in terms of remix in Dhurandhar movie. Yes, Nishika. So absolutely. See, a remix is also an adaptation of an existing song. Now, while this case is sub judice, so I wouldn't go on to the merits of it. But say in this scenario, T Series is the music label, right? Now, typically, a label which owns the sound recording rights and the underlying works. Sound recording is your main song, and underlying works is your lyrics and musical composition. Uh, Only if they own those rights can they make the remix of it. So I'm assuming they would have, they would have necessary reasons to believe that they do have the remix rights, and accordingly, those remixes would have been made. Or sometimes, if they do not have the rights, they go and procure it. Say, for instance, if there is another music label, say a Saregama, which had the rights of the first Dhurandhar film, there are also a lot of new recreations were made. Recreations is different from remix, where there are new lyrics which are being put, there are new composition, you hear a completely different avatar of the song. So those are also adaptations in which the rights need to be there. Only if you have a right as a label, the can you really give it ahead in terms of making the remix or the recreations.
Thank you so much, ma'am. There's one more question from the Overman Studio.
Yes. Sorry, I'll just read this. In collaboration with production houses, how are credits typically structured? For example, when does it become produced by, production by, or co-producer? How do you decide credit attribution when a production house is involved, mainly in execution versus creative contribution? That's an interesting question. This is typically commercially driven, and it always depends upon what the contractual arrangement is between the parties. Um, See, there are, and this is again not something which is driven by statute, but for instance, you would see that there is, when the film starts, there is a presentation by, right? So a studio will typically put their first presentation credit, then you will have an association with, then you will have the producer name, and then the co-producer. So these are all contractually driven when the agreements take place between the studio, the producer, or between two producers. There are different terms like co-producer, like you rightly mentioned. There is also an executive producer. Um, it all depends upon whose role is what, and how they have really agreed upon mutually between themselves in the agreement. That is how the credit attribution happens as far as the production credits are concerned. Of course, when it comes to writers, when it comes to any of the creative talent, there it, for instance, a writer, if he doesn't get a credit, then that becomes a moral right violation under the Copyright Act. So those are statutorily driven, where we have Section 57 of the Copyright Act, which talks about special rights of authors, and that is why those attributions you will typically see for writers, for lyricists, composers, etc. Likewise, for performers, we have moral rights. So those are covered under the statute. Uh, there's a question from Krishna. How can I get a license on contract basis of movies for YouTube or for any OTT platforms? See, this depends upon who really has the rights to monetize. So if, say, the producer has the right for giving it on YouTube, then you'll have to contact the producer. It really depends on who has the right, and whether they will want to put on their own on YouTube, or you're ready to give them certain amounts to acquire those rights. So you'll have to reach out to the right holder if you want to put the film on YouTube. And so would be the case for any OTT platform, because then you're actually taking it as an aggregator between the producer and the distribution platforms. I'll go to the next question from Likith. How can writers safeguard their pitch decks from not being exploited? Um, See, as a writer, it is very important, because I understand that for you all to be able to really see that the project is showcased to a production house, or when you're doing the pitchings, it's sometimes it's not possible to always have a contract in place. It's important to ensure that you have some evidence in terms of having created that pitch deck on your own. For instance, there is a Screenwriters Association, right? So, say if whatever concept you've written, if you've registered it with the association, there'll be a timestamp which will be put on it, which will be an evidence that you have written the work and it is registered in your name on a certain date. You can always share your pitch deck on email, saying that it is being shared in confidence. So what you can do by that is to ensure that there is a record which is there, that this is the work you've written and you're sharing it in confidence, so that tomorrow, should there be a situation where you feel that somebody has done it without your authorization and gone ahead and used your work, you have some evidence to pursue or to enforce your rights. So just have those basic lookouts in terms of creating that timestamp and evidence of creation of your work. There's a question from Harshini on what is an endorsement agreement. Sure. So endorsement agreements are typically done by celebrities endorsing the brands. So you'll have, say, for instance, a Deepika Padukone endorsing a Bisleri brand, right? Um, or an Allu Arjun endorsing Thumbs Up brand. When they do those endorsements, the brand, when they become the brand ambassadors of those particular brands, that is governed by what is called as an endorsement agreement, where again, the brand will pay a certain amount to the celebrity. There'll be certain shoot days for which the celebrity would have to go and do the shooting for whatever advertisements are concerned, or do the digital promotion on Instagram, etc. And whatever material is being created, it will be used for that particular term of the endorsement agreement. That is what endorsement agreements are. There's another question from the Overman Studio. Does co-producer credit depend only on financing, or can a production house that significantly contributes to execution and creative also qualify for it? See, like I said, it really depends upon the commercial arrangement between the co-producer and the studio or the producer. It is if I talk about industry practice, it is not uncommon for the person who is actually contributing on the execution to ask for a co-producer credit. In fact, the person who's financing it will typically want to have a main producer credit. So it really depends on the contractual terms, but standard industry practices, we've seen that co-producer credits are given to those who are involved in the execution. Another question from Nishika. Does the merchandise rights stay limited to certain companies or open for all? Since there could be many e-commerce websites who could be selling such t-shirts, posters. See, Nishika, typically when these merchandise deals happen, right? say a certain company is given the right to make the merchandise, to manufacture it, but when they want to exploit it, they would want to make the most of it, right? So they will not want, like, if I'm a producer, and if I want to actually make money out of my merchandise, I will want to put it in as many platforms as possible so that more people can buy it. So that really depends upon what the vision of the producer is. If they really want to make money out of the merchandising, then they will want to exploit it through multiple platforms. If they just want to do it for promotion, then they might keep it limited. I hope that answers your question.
I think we are done with the questions, ma'am. The moment I said there are no questions, we had a lot of questions. Thank you so much for answering each patiently and with huge clarity. Thank you so much, ma'am.
It was my
So,
pleasure.
yes, ma'am. Thank you so much for this incredible session, which it was a very comprehensive session, and I'm very sure that the creators who joined are, are benefited at a large extent because of you. And thank you so much, ma'am. Your skill which you have to simplify these concepts and convert it in the right way to deliver it directly to the filmmaking creators has been very, very helpful, and it is truly valuable and appreciated, ma'am. Thank you so much. I'm very clear, I'm very sure that our participants today would have understood all the things which you explained to them, and I'm pretty sure that they would have, if not very clear and all details they remember, but I'm very sure that they would now have a complete idea of how things work and what they should do and what they should be taking care of. So thank you so much, ma'am, in explaining all these details in the landscape of filmmaking, which started from protecting their ideas to giving them the right way to monetize their opportunities and creations. Thank you so much, ma'am. We, on behalf of IP Client, truly appreciate you taking the time and sharing your wise expertise in this industry with us, ma'am. Thank you so much. I thank all the participants for your time and effort. If there is one takeaway from today, if there is one key thing that we are going to draw, all the creators we are going to draw from this session will be: protect your work early and manage all your rights in the most efficient way, effective way, as much as you could, as far as you could, in order to gain a. Just a second. We have one more question, ma'am.
Yes, from the Overman Studio. For handling production agreements and legal structuring, whom should we ideally approach? An entertainment lawyer, a law firm, or a consultant? And what is the typical cost range for this? I'll be happy to take this offline. You can reach out to us for that. Yeah, but to answer your question, an entertainment lawyer would be the right person to guide through anything related to films because they would have the necessary expertise.
Yes, and for your kind information, IP Client does the same as well. So you can reach out to the either of us. Thank you so much, ma'am. So yes, I thank all the participants for giving your time and coming here. So yes, as I was saying, I want all the creators to stay cautious and protect your work early and manage your rights at the maximum extent so that you can strategically monetize your creation and get the best out of it. Yes, so see you all on another fruitful session. Looking forward to hosting you all on a wonderful webinar from IP Client once again. Thank you so much, ma'am. Thank you so much for coming today. Thank you.
Thank you so much. Thank you so much. It was a pleasure.